Welcome to my channel. Please like, comment, and subscribe. In this video, we are going to talk about Jones Act attorney. If you have been hurt on a vessel, the Busby law firm should be first called. We have handled cases against almost every vessel company in the United States. We have handled more of such cases than any other law firm. We know the law and the jargon. We know the insurance companies and lawyers who defend these cases. We do not lose. Our maritime attorneys are the only choice for workers injured at sea, on navigable waters, ship, channels, ports, dockside, or harbor. Our Jones Act attorneys in Texas have extensive experience in the requirements for eligibility to recover compensation through the application of the Jones Act and the Long-Term Harbor Workers' Compensation Act. We know how to win the compensation for you. The Busby law firm has the largest verdicts ever entered in the United States in the Jones Act cases. Call us for the result that you really need. And then the next is about the Jones Act. As soon as the Maritime Act of 1920 under 46 U.S. Constitution, the Jones Act protects crew members of a seafaring vessel in the event they are injured. This law applies to inland river workers and offshore crew members. These men and women worked on jack-up rig, semi-submersible, barges, drill ships, tugs and tow boats, crew boats, dredges, floating cranes, tankers, cargo ships, fishing vessels, chemical ships, research vessels, construction barges. They also work on a diving vessel, cruise ship, recreational boats, and other floating or movable vessels. Thanks to the Jones Act, these workers are not limited to ordinary workers' compensation when they are injured while working. The Jones Act offers more excellent avenues for recovery after an accident at sea or in a harbor. Compensation you can seek in a Texas Jones Act claim under the Jones Act. You can file for one or more of the following benefits: past, present, and future medical cost and care, loss income or wages, loss of future earnings, loss of ability to earn and money or diminished earning capacity, pain and suffering, physical scarring or disfigurement, home and living cost while the person is in recovery, mental anguish, vocational rehabilitation, temporary or permanent disability. If the injuries lead to a loved one's wrongful death, select relatives or dependents may be able to file for the following damages: compensation for funeral cost, loss of companionships, loss of consortium, pain and suffering arising from the loss of the family member, loss of income, medical costs incurred before the person deceased. Depending on the situation, you or the loved ones of deceased offshore work may be able to claim all these damages. Our Texas Jones Act law firm will provide legal advice in this regard and guide you so that you can get the maximum settlement possible. Who can you file a Texas Jones Act claims against? As an offshore worker in Texas, you are entitled to a safe working environment. Specifically, your employer should provide a reasonably safe working environment. Through ordinary care, ensure that all sea vessels that maritime workers will work on an reasonable staff condition. Ensure that there is a maintenance and care process in place if employees fall ill or get injured. If an employer, shipping company, or vessel owner refuses to provide this, you can hold them liable. But that's not all. They can also be held liable in the following circumstances: clear negligence of safety protocols and processes, intentionally endangering the lives of the crew by placing them on unseaworthy vessels, injuries or illnesses suffered because of their negligence, your employer forced you to work in conditions that are clearly unsafe, your employer declared and used faulty equipment. Proving negligence in a Jones Act case. Proving negligence in a Jones Act case requires a long burden of proof than workers' compensation or personal injury claims. All it takes is some evidence that the employer's negligence, no matter how small, contributed in some way to your accident and injuries. Once you are able to prove this, you qualify for compensation under the Act. Also, you may be able to sue third parties for negligence too, thus increasing your compensating amount. but those are particular circumstances that your Jones Act lawyer in Texas will explain to you if necessary. Finally, please understand that there is no set time frame for these kinds of cases. Some are resolved within a short time, others takes longer. It all depends on investigation your attorney carries out, the willingness of the company to settle, and how much you are asking for as compensation. And then Jones Act attorney. If you need a trustworthy, proven, and effective legal counsel that understands the Jones Act and knows how to win offshore injury cases, the Busby Law Firm should be at the top of your list. Our lawyers have made a name for our firm, bringing us many referrals over the years. And then Jones Act attorney. If you have been hurt on a vessel, the Busby Law Firm should be the first call. We have handled cases against almost every vessel company in the United States. We have handled more of such cases than any other law firm. We know the law and the jargon. We know the insurance companies and lawyers who define the cases. We don't lose our maritime attorneys as the only choices for workers injured at sea or navigable waters, ship channels, ports, dockside, or harbor. Our Jones Act attorneys in Texas have extensive experience in the requirements for eligibility to recover compensation through the application of the Jones Act and the Longshore and Harbor Workers' Compensation Act. We know how to win compensation for you. The Busby Law Firm has the largest verdicts ever entered in the United States in a Jones Act cases. Call us for the result you deserve. And then also known as the Merchant Marine Act of 1946 U.S. Constitution, the Jones Act protects crew members of a seafaring vessel in the event they are injured. The law applies to inland rivers or workers and offshore crew members the men and women work on. Jackups, semi-submersible, barges, drill ship, tugboats and towboats, school boats, dredges, floating cranes, tankers, cargo ships, fishing vessels, semi-gull ships, research vessels, construction barges. They also work on a diving vessel, cruise ship, recreational boats, and other floating or movable vessels. Thanks to the Jones Act, these workers are not limited to ordinary workers' compensation when they are injured while working. The Jones Act offers more excellent avenues for recovery after an accident at sea or in a harbor. And then compensation you can seek in a Texas Jones Act claim. Under the Jones Act, you can file for one or more of the following benefits: past, present, and future medical cost and care, lost income or wages, loss of future earnings, loss of ability to earn an income or diminished earning capacity, pain and suffering, physical scarring or disfigurement, home and living costs while the person is in a recovery, mental anguish, vocational rehabilitation, temporary or permanent disability. If the injuries lead to a loved one's wrongful death, select relatives or dependent may be able to file the following damages: compensation for funeral costs, loss of companionship, loss of consortium, pain and suffering arising from the loss of the family member, lost income, medical costs incurred before the person damages. Depending on the situation, you are the loved one of the deceased offshore workers may be able to claim all these damages. Our Texas Jones Act law firm will provide legal advice in this regard and guide you so that you can get the maximum settlement possible. Who can you file a Texas Jones Act claims against? As an offshore workers in Texas, you are entitled to safe working environment. Specifically, your employer should provide a reasonably safe working environment through ordinary care. Ensure that all sea vessels, the maritime workers will work on a reasonably safe condition. Ensure that there is a maintenance and care process placed in impossible. Employees fall ill or get injured. If an employee, shipping companies, or vessel owner refuses to provide this, you can hold them liable, but that's not all. They can also be held liable in the following circumstances: clear negligence or safety protocols and processes, intentionally endangering the lives of the crew by placing them on an unseaworthy vessel, injuries or illnesses suffered because of the negligence, your employer forced you to work in conditions that are clearly unsafe, your employee deployed and used faulty equipment. I think that's all guys, the information that I can share to you. Thank you so much guys for watching, and if you need information related to maritime topics, you are in the right channel. In this channel we provide a lot of information related to maritime topics. Don't forget to share this video to your friends, family and your loved one. Maybe they need information about maritime topics. So thank you so much guys for watching. I hope you can take a minute from the video that I've said to you. I hope you like the way I deliver the explanation to you guys. Thank you so much for watching. Don't forget to give like, comment and subscribe to this channel guys. Bye bye, see you in another video.